Arkansas Supreme Court judges, faculty members of the Arkansas School of Law, and students and members of the Board of Trustees, and friends of the law school. I'm really happy to be here on this absolutely beautiful day to see the lovely law school building that you now have. I visit plenty of law schools, and I know of none that is any finer than what you now have. It's really a wonderful building, and I know how proud you must be to have it. We're living in some tough times right now. People are beginning to struggle with their economic situation. And there's a verse in the book of Proverbs in the Bible that says, wisdom is better than gold. Now, I think that's right. And that's what this university is all about. That's what this law school is all about. Teaching a few things that may give us a bit more wisdom, and we can certainly use it in today's world. And I'm very happy, Dean Nance, that you included me in this special day. And with this new space over here, I think you gained about 64,000 square feet with classrooms and reading rooms and a courtroom, but also an espresso cafe. Now, with your new facilities, you're going to be well equipped to meet the demands of contemporary legal education. And with the espresso bar, you're going to be well caffeinated. This renovation and expansion will encourage excellent academic achievements. It's going to nurture some interesting and new scholarship, and it's going to nourish a sense of community among the students and the faculty and the staff, and I hope the alums. I hope it will do more. I hope it will inspire the students here to take an active role in our nation's ongoing efforts to secure fundamental liberties for all of our citizens. To that end, let me draw your attention to one of your new spaces, the seminar and meeting room, named for your 6 pioneers. The room's namesakes were the first 6 African-American students to attend this law school. Silas Hunt was the first in 1948, 1 year before I started law school out in California. Now, the other named pioneers, Jackie Shropshire, George Haley, Christopher Mercy, Wiley Branton, and George Howard Jr. followed in the next 3 years. Now, Mr. Hunt was admitted without litigation or violence, making this law school the first in the South voluntarily to admit an African-American student. The school's decision to admit Mr. Hunt is one you can be very proud of, but in honoring the remarkable example of these 6 pioneers, it's important to remember what is meant by voluntarily and admit. The law school's dean at the time, Robert Leffler, recognized the forceful movement for racial equality in education, and it was gaining momentum across the country. He wisely concluded that by failing entirely to offer legal education to African-American students, the school found itself on the wrong side of that movement, the wrong side of history, a position which could not continue for very long. To his credit, Dean Leffler successfully lobbied the university's administration and Arkansas Governor Ben Laney voluntarily to admit African Americans to the law school. This did not, however, mean full access to the school's offerings. A segregated program of study was established. Mr. Hunt was admitted to this separate program. He was taught each of his classes individually in a separate classroom. He was allowed to borrow books from the law library, but he had to use them in a separate study room. He was not given access to the library study spaces used by the other students. And Mr. Hunt was not allowed to use the student restrooms. He had to ask the dean's secretary to use the dean's facilities. Now, when classroom overcrowding and other practical realities led white students to complain about the one-on-one instruction Mr. Hunt was getting, and his immediate successor, the same, Mr. Shropshire, the dean decided that Shropshire and Hunt would join half of the white classmates for a second section of 2 classes, and a wooden railing. Hunt began his legal studies here. In Brown, the U.S. Supreme Court held that the doctrine of separate but equal was unconstitutional as applied to public school children. It struck down the legal fiction that children of different races received equal protection of the law even though they were forced to attend separate schools. And the first step towards Brown came 60 years earlier, just as the court first adopted the doctrine of separate but equal in that old case of Plessy versus Ferguson. In Louisiana, white and black train passengers were separated by law, but Mr. Plessy refused to move from a white railroad car to a so-called colored railroad car. He claimed that Louisiana's law violated his rights under the 13th and 14th Amendments to the Constitution. Unfortunately for Plessy, the Supreme Court of the U.S. upheld his conviction in an opinion full of thoughts that seem foreign to us today. It held that laws requiring the separation of the races do not necessarily imply inferiority of either race, and were normally within the powers of states to enact. As examples, the court offered state laws segregating schools, prohibiting interracial marriage. It thought such laws were permissible. In fact, the court thought that the separation of the races was not a problem because it had nothing to do with political or legal equality. If any such law created a badge of inferiority, it was, and I quote, solely because, said the court, the colored race chose to put that construction on it. Now, the only dissent came from Justice John Marshall Harlan. Although it was only one of many dissents he wrote over the years, it's the most famous, and rightly so. Justice Harlan first said what everyone knew. The Louisiana law was not meant to exclude white people from black railroad cars. It was only meant to exclude black people from white people in railroad cars. That meant that the law obstructed the civil rights of blacks and whites to travel together at will. Justice Harlan found the case easy to decide. He said, in view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizens. There's no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or his color when his civil rights, as guaranteed by the supreme law of the land, are involved. And Justice Harlan predicted that in time, Plessy versus Ferguson would turn out to be as pernicious as the old Dred Scott case, and he was right. But at the time it was written, it was only a dissent.